Good morning, President Murray, and thanks for listening to my legal recommendation for Whitman College. I'm basing it off of this case from 2002. It was Gonzaga University et al. Versus John Doe. I believe that this relates to our university, to our college, but because Gonzaga is a small private college in the state of Washington, much like Whitman. And I also feel that because this case deals with the Federal Educational Rights and Privacy Act of 1974, or FERPA, that it is very salient to the issues of the day, because I really believe that issues of a right to privacy will continue to be very topical and in the news within the next coming decades. So let me touch a little bit of background on the case that I am discussing. As I said, this is a case, Gonzaga University et al. V. John Doe. This is a case that touches heavily into FERPA issues. Let me just go ahead and remand what has happened. So basically, the issue of the case deals with, in 2002, an undergraduate student at Gonzaga University. The student was attaining a degree to become a public elementary school teacher. And as you know, in the state of Washington, all new teachers are required to attain an affidavit of good moral character from their graduating college. Now, in this case, the teacher certification specialist at Gonzaga overheard a conversation being had by two different other students, undergraduate students, where it was revealed that the undergraduate student in question seeking to become a public teacher had engaged in sexual misconduct. Okay, because of this, the certification specialist contacted the state agency responsible for certifying teachers and discussed the allegations, including using the student's full name. Now, because of this, the student did not receive an affidavit from Gonzaga and was not allowed to become a public school teacher. The student was upset with this, and they sued the institution in state court, alleging that FERPA had been violated because his records were released without his or his parents' written consent. The student was originally awarded punitive damages and compensatory damages by the court, but it was subsequently reversed in the Washington State Court of Appeals on the ground that FERPA doesn't create individual rights. It was then sent to the Supreme Court of the state of Washington, which they reversed the appeal, saying that FERPA does not give rise to a private cause of action, but the non-disclosure provision creates a federal right that is enforceable. So because of the going back and forth, they had to send the case to the Supreme Court of the United States. So it was remanded to the U.S. Supreme Court, where it was argued April 24th, 2002, and decided June 20th, 2002. The question presented to the court was simply this: may a student sue a private university for damages to enforce provisions of FERPA? Now, in a 7-2 decision, the Chief Justice William Rehnquist's court found that no, a student does not have the right to sue a private university for damages over FERPA violations. So on the majority side, we had Chief Justice Rehnquist, Justice Sandra Day O'Connor, Justice Antonin Scalia, Justice Clarence Thomas, Justice Anthony Kennedy, Justice David Souter, and Justice Stephen Breyer, who wrote the concurrent majority opinion. The two dissenting judges were Judge Ruth Bader Ginsburg and Justice Ruth Bader Ginsburg and Justice John Paul Stevens. So the court found that no action was ruled out because the provisions of FERPA do not create any personal rights to be enforced. So they agreed with the original reversal at the Court of Appeals in the state of Washington. Furthermore, the court also found that creating rights would have to be put in clear and unambiguous terms, which FERPA and their provisions do not contain. A quote from Chief Justice Rehnquist in his decision is, FERPA's non-disclosure provisions contain no rights-creating language. They have an aggregate, not individual focus, and they serve primarily to direct the Secretary of Education's distribution of public funds to educational institutions. So Chief Justice Rehnquist and the majority looked at the precedent set in Pennhurst State School and Hospital versus Halderman, where it was made abundantly clear that unless Congress unambiguously expresses intent to create individual rights, federal funding provisions do not provide a premise for private enforcement, so private individual enforcement like this case. Chief Justice Rehnquist argued that Congress enacted FERPA under the condition that the Secretary of Education has the right to revoke federal funds, for any public or private university institution that has a policy or practice of releasing educational records. So at the end of the day, what the court is saying is that individual violations of FERPA in a manner such as this case do not rise to the level of consideration. A case of mass exposure, premeditated pattern of violations by an institution would have a different answer. That would rise to the violation would rise to the level where Congress would revoke the federal funding as a consequence. But in this case, a single person technically violated FERPA by talking about the student's name to the certification specialist in regards to the sexual misconduct. But the court speaks very clearly on this issue, plainly stating there's no question that FERPA's confidentiality provisions create no enforceable rights. So according to the court, this is a cut and dry situation. But Justice John Paul Stevens, in his dissent, wrote that it could be interpreted in many different ways. He wrote that the ruling may be read as accepting the proposition that FERPA does indeed create both parental rights of access to student records and student rights of privacy in such records, but that those federal rights are of a lesser value because Congress does not intend them to be enforceable by their owners. He brings up quite a few things in his dissent. He starts by criticizing the blanket approach. He also points to language in the written law of FERPA that specifies that a student, rather than students generally, are protected. He argues that FERPA has a stated purpose to protect individual rights to privacy in the way of limiting their transfer of their records without written consent. He also points out that rights is in the acronym for FERPA and the myriad ways that rights are referred to in the language of the law. But his largest contention is the precedent set in other state courts and federal appeals courts. They have all said that FERPA creates enforceable rights and that the expression of rights has been backed up by all other federal and state courts, as well as Congress not overriding any of these decisions by amending the law. And so he wonders why is it when it gets to the Supreme Court that it's different. So I believe that as a private institution like Gonzaga, Whitman has a pretty large interest in this case, and the implications that at a smaller one, and the implications is that is similar to our college at Whitman. The right to privacy is paramount in society, but if you see technological advances and government directives have made that blurry. There are many different ways that this type of issue could pop up again. I read an article on Inside Higher Ed that discussed how FERPA was changed a bit in the wake of 9/11 and the Patriot Act. There were less protections for students. Another thing I thought about was Apple's refusal to encrypt the 2015 San Bernardino shooter's iPhone to get the data from the phone because they thought it was an invasion of privacy. So these types of things are going to continue to be in the news. Another thing I've thought about is the transfer of educational records from paper to digital have much bigger potential to be hacked and leaked to the public. I'd like to take a look here at a couple of potential scenarios that could happen. Obviously at Whitman, one of our most popular majors is psychology. I was thinking there was a potential situation that could arise where a student is attending with the intent to become a licensed psychiatrist, divulges a personal opinion that could be considered bigoted if this session were in a digital record, never had come out before, but then later in life the alumni is released, and the alumni who is now a practicing psychiatrist, this is released, maybe they end up losing their practice because of this, they lose patients and things like that. A case like this could possibly change the precedent of the court, because if the records are for alumni and the individual was deprived of significant monetary means because of the release of records. Another scenario would just be the mass hacking of records. Obviously this is not an individual case, but I'm thinking that if a certain amount of records were released, then there would possibly be lots of individual cases where maybe sexuality, health records, grades, things that don't need to be out there are out there. I think that would bring a lot of individual cases that could possibly change the precedent. So my suggestion would be to simply invest heavily in data security systems to safeguard the privacy of all educational records related to Whitman College. There's no turning back from the shift to digital records, but every measure must be taken to ensure that servers are secured. It would be highly unlikely someone would break into a specific office and take a file, but it's much more likely that they would be hacked digitally. I also think that maybe flagging, red flag behaviors is what I'm calling them, that show up in educational records, things like sexual misconduct from the original case, reporting of these red flag behaviors, not reporting to the public, but internal reporting, will decrease potential liability in a situation where a student who is graduated and given an affidavit of good moral character and then engages in sexual misconduct. But the final recommendation is simply to turn a tight ship in terms of records, because the right to privacy is not going to go away as an issue in the future, and I think this case is something we need to continue to look at for Whitman College.